So welcome back, everyone. Our next panel discussion is on intellectual property and global trade, navigating cross-border challenges. Please join me in welcoming our distinguished panelist. Our first panelist is Mr. John Cabeca, U.S. Intellectual Property Counselor for South Asia. Let's have a huge round of applause, everyone, for Mr. John Cabeca. Our second panelist is Ms. Monica Romelina Sijabat, founding and managing partner at MRS Business Professional Consulting, who is also our presenting sponsor. Let's have a huge round of applause, everyone, for Ms. Monica. The third panelist is Mr. Gilbert Boon Keat, Regional IP Counsel at Yokogawa. Let's have a huge round of applause, everyone, for Mr. Gilbert. I warmly welcome all the panelists.
Okay, good afternoon, everyone. We have the wonderful advantage of being right after lunch on a Friday afternoon, so we're all primed and ready for a very engaging and enlightening discussion. So I just want to take a moment to welcome my fellow panelists, Monica and Gilbert, here. What we'll do is each take about 5-7 minutes or so to tell you a little bit about our very diverse roles. It's a very diverse panel, and how it intersects with today's topic and the topic of this conference. And then we'll go into Q&A and have hopefully an engaging discussion from all of you as well. So I'll start and just briefly introducing myself. John Cabeca. I am the USPTO Regional Intellectual Property Counselor for South Asia. So I'm based out of the US Embassy in New Delhi, and I serve all the South Asian countries, including Pakistan, Sri Lanka, the Maldives, Afghanistan, Bhutan, Bangladesh, and Nepal. And so, and so I've been there about 4.5 years. And even today, I got questions about why is the USPTO putting IP counselors, IP attachés in respective countries throughout the world. And I think it's important to highlight the fact that the head of the U.S. Patent and Trademark Office actually serves as the principal advisor to the President of the United States on all forms of intellectual property. And she is also responsible for administering our agency of 13,000 people, where we grant patents and register trademarks. But in the advisory role, that responsibility isn't just domestically, it's also internationally. And she plays a key role in our international dialogue with other trading partners, both bilaterally and multilaterally through many of the different WIPO organizations in Geneva, and through other forums like the Quad, for example, which is a partnership with Australia, India, and Japan, and several others. So in this vein, what we do is we play a very close role with the governments throughout the region. So, and we obviously have a wonderful relationship with all of the IP offices in South Asia, for example, but that's not where we stop. We're not just working with the IP office. We're working across the entire government, foreign government, on anything that might be in the works, guidelines, legislation, rules, regulation, anything that might implicate intellectual property in some way. So in that way, so for example, think of drug regulators, or think of in the telecom industry and data privacy, digital privacy, and things like that. So we do work across the spectrum in that regard. And that's a big bucket of what I do, the G to G bucket. The second pillar of my work is more C to G, it's B to G, I guess, business to government, and where I work very closely with industries that have a significant presence in the United States, that also are active in countries throughout the region, or are seeking to enter one of the countries in my region. And we work with them on sharing best practices, especially highlighting differences between our respective laws, how the courts work, different enforcement regimes, and so on. So that's a big part of what I do. And then if I see something that is more systemic and perhaps impacts more than one company, then I go back to my G to G bucket in advocating for improvements of that policy or law in my work with the government. And then the third pillar is one of, I guess, G to P, so it's government to public, and it's working across the innovation ecosystem at all levels with law experts like yourselves down to kids in schools and across all forms of intellectual property to help raise awareness of intellectual property, the need to respect intellectual property, and how to employ IP strategically in advancing your own business interests. So that's a big part of what I do. I'm not the only one in the world. You're probably all sitting there, yeah, he covers South Asia, why is he in Singapore? I do have a counterpart that covers Southeast Asia, who's based in Bangkok, who is unavailable to join for this program. So I came in his place. But also, I share this because if you ever want to reach out to the IP attaché, whether it's Southeast Asia, South Asia, we have 3 in China, we have some in Europe, Central South America, Mexico, please reach out to us. We welcome the discussion, helping to answer questions and helping to not only to hear what some of your experiences may be, but also to help in establishing a path forward for stronger, more effective IP protection. So with that, I'll stop there. And just to say that I've been with the U.S. Patent and Trademark Office now 35 years, and prior to coming to India, I was the regional director. I opened and ran the Silicon Valley USPTO for 7 years, based in San Jose, California. So worked very closely with startups, worked very closely with high tech, biotech, and some of the most innovations coming out of the country. So thank you. Monica, I'll turn it to you. Are you on Gilbert or whichever?
Oh. Go ahead. You me first? Yes. Right. Hi everyone, my name is Gilbert Tan. I've been in IP industry since 2008. Before that, I'm a trained engineer doing ICT science. And I think many in this room are not familiar with IP, right? So maybe I touch base a little bit. Intellectual property is something that you're intangible, right? That is an asset. So I didn't know actually how good it is until I went to see a customer. At that time, they are surrounded by like 10 people speaking in a foreign language that I don't understand, and everyone was like very angry at me, and scold. And I was like, okay, I don't understand a single word what you say. I know you're very angry, right? Then I asked my sales guy, why those people are so upset? Then they said, they don't like your product. And I said, you don't like my product, then don't buy. Why you bring me here to scold me in a language I don't understand, and then you still buy from me? And he said, that's the problem. You have IP, you have patents. Then I realized, wow, okay, IP is the way, right? And some, as an engineer, I also have some inventions that eventually, we apply patent, and then I see the value of those patents. So as one of my ex-boss told me, IP, writing IP is like printing cash, right? So if you apply patent, right, depending on the contents, it can be a junk, a piece of paper writing something, or it can be something that worth millions or hundreds of millions of dollars, right? That is how powerful IP is. So I'm glad that I'm in this field because since 2008, my ex-boss say, hey, wait, you have been outside IP department, why don't you come in? So I came in, then transformed my career, and now I'm regional IP counsel for almost 8 or 9 years already. And for IP, it's really complicated. It's not as easy as what most people think. I just now mentioned patent, and you have also copyright, trademarks, trade secrets, and all form of stuff. And with this new age, with AI, right, I would say there is new form of IP in the form of learning model. So things are complicated, not as easy, and especially you want to enforce that across the border is even much, much more challenging, right? So I think we are living in this excited period where you see, AI, all these new things are ongoing, but at the same time, I think it's also a challenge to enforce those $1 million IP, right? To make sure that it has those value. Okay, I think I have give enough. Pass the mic to Monica.
Hello everyone, I'm Monica Romelina Sijabat. I believe that we are meet in New Delhi March 6 and 7 as an awardee LexTalk Global Award 2024, and that we have good communication and connecting also that the familiar people there. I'm so happy to meet you here again and again also. So I'm the founder of the and managing partner for the MRS Species Professional Consulting. I built my business 9 years ago with my success team, and then they are with me right now. And we have the team from the top university in Indonesia that as of University of Indonesia alumni. And then we open our new representative office in Washington, D.C. When the COVID come, so that John, when you are in New Delhi, I'm in Washington, D.C. Yeah, we fight for this business because that our client, they headquarter in Washington, D.C. And our client is they are also success 300 years ago in America. So that's why that we open in Washington, D.C. And in Indonesia, the first success story I start with the status lecturer as a text lecturer in University of Indonesia. Why I got my sparring managing partner awardee last March in New Delhi? Because I have a lot of profession with me as a tax attorney, as a consultant, as a lecturer at the time, and now as the researcher, so that you can explore the world with very best in your life. That's so inspiring for the people. So when I got my status as the lecturer, as the people that are highly competitive to become a lecturer at the top university in Indonesia, that we call it Universitas Indonesia in Bahasa Gilbert, familiar with Bahasa. And most of the people that come to a university to know about how you experience as the tax attorney. Because in regulation first, tax is different with the law, the specific arbitration, intellectual property, and anything. Why we talk about the intellectual property now? Because when you have a script, when you continue to the court and the Supreme Court, your script as the have intellectual property right. In Indonesia, we call it hak kekayaan intelektual. We are rich people that have right as the author. It's translated in English. So John and Gilbert have a big smile when I explain in Bahasa, translate to English. So intellectual property is so important for us. When someone want to cheat your script, it's related with your right in intellectual property. So who's the people that want to duplicate your script? Who's the people want to cheat your script? Who's the people want to get the benefit in it? Who want to compete with you, but they do something not related with the good effort that related with the intellectual property right. That's why that we talk about intellectual property. I believe all of us as the legal professional background, you have the script, right? So that we will talk about it later after this session opened by John. How you successful with your script as your intellectual property right. As in Indonesia in Bahasa, we call it hak kekayaan intelektual. Is it correct? Correct, right? So we are rich people as the author of the script, correct? We have Indonesia right now here. So yeah, because that if you plagiarism in University of Indonesia, we will terminate you and you will fail in that semester. So we will punish you as a student. So it's so hard and difficult. When you do cheat and you duplicate, or maybe that you stole that script, so you will get the big punishment. That's why that we call it in Indonesia, hak kekayaan intelektual. It means that you are rich people that have right as the intellectual person. That you are also a brilliant people when you win the case in the court and the Supreme Court. That's why we keep, as a attorney, I will keep it by myself and then go direct to the court. So auditor cannot cheat it. So the another consultant cannot cheat it. So they cannot duplicate it. Why? Sometimes in our profession, we compete must support and sportive, and we know that how strong we are compared to another professional background. So the intellectual property is very, very important to our professional background as a legal, as an attorney, and also that the person that is related with it, especially for the business, that the patent and others. That's so very, very, the very big value in the business. Okay, this is me. Thank you so much, everyone. Come back to you, John.
Sure, thank you. Thank you, Monica, and thank you, Gilbert. So when we think about the theme for the conference, global, legal, and IP, as we see in today's globalized economy, safeguarding innovations requires a multifaceted approach that addresses legal, technological, and strategic considerations. And we're going to touch on these a bit today. But the rapid advancements in innovative and transformative technologies, you heard Gilbert talk about AI, and then the panel just preceding lunch on blockchain, continue to reshape IP laws and strategies. At the USPTO, we're taking this very seriously and have taken also a multifaceted approach, not just within the USPTO, but also in partnership with the Copyright Office and in partnership with other government agencies throughout the US to figure out the best way to address AI considerations at the intersection of innovation, creativity, and IP. However, across jurisdictions, and not just developed versus developing, but just generally across jurisdictions around the world, the lack of harmonization among international laws and regulations is one of the primary challenges in cross-border IP protection and enforcement. And this is very challenging for businesses, particularly operating in multiple jurisdictions. So I'll just highlight some that I deal with on a regular basis in my current capacity, and then we'll talk more about some that impact broader than intellectual property. So for example, in the patent system, the US is a first to invent system, where first inventor to file system, whereas some places around the world they're still first to file. And other countries have different scope of patentability protections, where you might be able to get effective protection on software-enabled inventions in one country, and the same claims would not be permitted in another country. Similarly, in pharmaceutical areas, you'll see in countries like in India, there's a statutory criteria for enhanced efficacy, which makes it more challenging for innovative pharma to obtain protection and therefore enforce their innovations in that jurisdiction. Also, there's a variety of different terms of copyright protection around the world. There's a baseline at TRIPS at 50 years, but we've been encouraging partners to expand that number to 70 years from the author's life. In addition, trade secret protection is very challenging, and this is something when we talk about startups, for example, the first type of intellectual property a startup creates is typically a trade secret. They're iterating, they're innovating, they're prototypes, they're recasting, pivoting, doing all of these things, and they're trying to keep that out of the public domain. So ensuring that they have strong relationships with their employee to employer, as well as with manufacturers and other entities, distributors that play an important role in the research, development, and commercialization of a product. So you heard yesterday, so kind of turning to one thing I saw is interesting fact that I hadn't heard too much about prior to this conference. And Monica, in her opening remarks yesterday, talked about international asset transfers and an increased focus on intangible assets with respect to taxation. And as a result, intangible assets, intellectual property is an intangible asset and plays a key role here. So maybe perhaps I'll start with Gilbert and then to Monica, if you can maybe explain the issue a little further in the real world, and then provide some examples of some countries where it's actually navigable and some other countries where it's challenging to deal with these cross-border asset transfer of innovations. And what are some strategies that can be considered for companies to help navigate the differences across the jurisdictions?
Okay, sure. So IP actually is a very broad area. You have trademark, copyright, and patents, and so on. So it's very difficult to like one answer fits all. So maybe I just pick a few, right? If later on you guys have any specific interest in one area, maybe you can ask me, right? So maybe let's take the trademark. Okay, trademark in most countries you have registered trademark, and you have non-registered trademark, right? So if you think about registered trademark, then you have to register in that country. So if you have business operation in 10 countries, then you need to register that in that 10 countries. So trademark, I think the fee is not that high. It's not that much an issue. So if you really care about your mark, then you just register there, right? Problem solved. But the problem is a lot of people, they don't, right? Then later on they realize, hey, wait, I use this mark in Singapore, right? Then this guy is getting my mark in, let's say, the neighboring country, Malaysia. What can you do? So of course, this type of stuff to me is, if it's not so much a burden, just settle it, right? For patent, then it's not that cheap, right? Because the fee for trademarks, if you know, is a range of few hundred. But if you talk about patent, it's easily thousands or tens of thousands. So do you want to file in like multiply by 10 by this 10,000? It doesn't make sense, right? So you have to figure out something like, maybe you just protect some country, not all the country. So you have to think which one is the one that you want to file your patent in that country, right? So let's say you have your business in 10 countries, maybe you just select one or two, right? So it really depends on how you want to deal with it. Then for things like copyright or any other intellectual asset that you do not need to register, then I think maybe it is not that complicated. But again, you need to rely on the local law, right? And in some cases, enforcement is not that easy. So to be honest, you don't expect to be able to enforce your IP right in every country with limited budget. So you just need to figure out how to maximize what you can do, right? Then John talked about second issue about transfer of asset. And to me, this will be something very exciting in the next 30 years. Because in the past, people talk about asset as tangible. But now, I think more and more people can accept that intangible asset, which is IP, can be even more valuable. So more and more countries recognize that, and I was just discussing with my fellow panelists that in Europe, the patent office or maybe the authority, right, start to look at this. They were saying that, hey, wait, the inventor invented this invention, let's say in one of the European country, and then you registered that patent, right, or then you transfer to the US or somewhere outside Europe. And when you are successful in your business, they don't get tax, right? No, you get tax somewhere. Let's say the business, went from Europe to US. US taxed the company for making profit on the invention originated from Europe, but Europe government don't get a single cent, right? So for that reason, the government authority look and start to scrutinize more and more on this. But let me ask you, when you file the patent, what is your value of the patent? Just now I told you, right? It can be as good as just a junk paper, or as good as tens of millions of dollars. So the variation can be very, very difficult, and this kind of issue can be very, very complicated. So how are we going to deal with that? Well, I'm not a tax expert. Maybe Monica can explain better. But the strategy that I always tell people to use is before you get your IP right form, transfer it, right? So meaning if you have application before your patent get granted, then you transfer, right? It's of course common sense that before grant, you are not sure whether your patent can be granted or not, will have lower value. And once it's granted, it's for sure you have that right. It will be higher value. So you need to act early. And if you look back at everything I said just now, right? You just need to prepare early, right? If you think that you will be successful in those countries, file your trademark, do whatever you can, talk to the IP attorney in that country, and see how your IP right can be protected. That's all I can say.
Yeah, Monica, let's hear from you on your perspective.
Okay, as a consultant, that maybe that this is just share with the real case, but we must keep confidential. For the technology right now, that is very, very hot issue for the business country by country. And royalty also, and intellectual property also, and the patent also, that all of the business strategy that they concern about, that who is the author, who is the have to write there for the intellectual property, and how about the impact to the tax for the headquarter or for the others, for the branch in other country. So related with intellectual property, that Gilbert shared with us just now, that about the patent, that this is very expensive also, and how about the value. But when you have the first that you know who is the author, that they automatically that become that have the right for the intellectual property, right? So if the first one and compared to the have the who's the author, this is different in my perspective. Who is the author, who is the manuscript, but who is the execute, such as us in the legal professional. So I'm the author of the script, okay? But who is the execute? The person that goes face the judge in the court, that's the different. So in tax is the same thing. So which one that have the intellectual property right here? In me, in the tax professional background, that regulation, I'm the person that who have the intellectual property right. I can sue the person, my team, that go to the court with my script. That's in my experience. So related with the technology, it's the same thing. When the case of the intellectual property right for the digital company that happened, it's very popular case at the time, that we have the same case also. So then the intellectual property, who is the author of this one first for the to make this digital product first, and the software and else and else. So is the person or is the company, right? So when the person that as the author, that he or she have right to do that, and then who got the money and who got the benefit from this? Is this the company or the person? So the tax will tax to the person or to the company. It depends who get the income first. So that's why that we call it in tax treaty that who is the source income. So the person or the company that will tax for the intellectual property, that he goes with it first, that as author. So we know that which country that most popular and that they have the technology, the very high competitive in another country, country by country, they put in another country also, is so different in the tax. So in tax regulation, not even in any country, we know about the tax treaty to avoid double taxation. So the author that and the source income that will get taxable first and not to the another one. Why? Because he gonna be that have the right and that he gonna be the source income first. That's intellectual property right related with tax also. And the pattern that you said that we also have a royalty in tax also, it's so difficult to prove it if you know who's the branch or the headquarter that will give it to you and who's gonna be the person or the company that get the benefit. That's a reality first. So most of the case in the pattern or royalty that related with it and the author and also that the person or the company must continue to the court in the tax issue to prove it first. Most of the tax authority that they cannot handle about this case for the digital company that have the technology product that very, very highly competitive with another one that they have popular brand right now. So that's based our experience, John, about that we cannot specific to name it, so sorry, but I believe that you understand if you are a legal person, who is the author, and then who is the person, your team, to execute it. Okay, you got it now? So yeah, you smile, it means that you understand what I mean. Yeah, John, because this is very confidential, but I believe all of you that know about this case, this very popular case, and who is the winner in this case. So please be careful who is the author and who is the executor. It's totally different in taxation regulation. Thank you, John.
Thank you, Monica. I'll just, in the interest of time, just ask one last question to the panel. And I talked a little bit about trade secrets and the difference in protections in trade secrets across the world, and very much so even in South Asia. There's only one country that has even a mention of trade secrets in their law, and that's actually Sri Lanka, but none have a clear, effective trade secret enforcement mechanism. And you know, we hear from judiciary that the hodgepodge of laws that are, you know, put together to meet the TRIPS obligations for handling of confidential business information and trade secrets are very difficult for a judge to adjudicate accurately. So, and I think, you know, going kind of taking the bigger picture here. So even though the regulatory environment and the enforcement, IP enforcement environment is very challenging in many countries around the world, these economies are still very attractive to investors. And I've heard from investors who say, okay, we're going to invest $20 million in this new manufacturing facility, but we really wanted to invest and prepared to invest $200 million. But, you know, so even though the economy is attractive and they're not investing at the rate they would be if it had stronger protections for IP. And I think maybe, Gilbert, I'll turn it over to you to share your experience here on what are some things that companies can do when considering effective protection in markets where the enforcement of the intellectual property is not as strong as perhaps on the international best practice standards.
Okay. Yeah, I think John has pointed out that not that many countries have this law regulating trade secret. Yeah, I think it's true. Most people will just most countries just refer back to TRIPS agreement and refer to the condition there. From my experience, I think the difficulty is not so much about the law, because the law from employee context, right, is kind of like clear. Whatever that you come up with is belong to your company, your employer. To me, the difficulty is about enforcement. And enforcement, well, of course, the strong regulation is needed, but a bigger headache is evidence. So if someone stole something, right, from the company, let's say from your company, I think the first difficulty that you will face is how do you prove that information is confidential? And I think most employer, especially small, medium enterprise, they were like, what is that? Right? And if you if you act like that, then you can only say, yeah, what is that? You can't do much, right? So in that context, you need to understand, right, what constitute a confidential information. Of course, it's too much to talk about in this short time, right? So talk to your lawyer, get to know what are the conditions, and usually it is best that you prepare yourself better, right? Like labeling those things and make it clear. That would do the work, right? One thing I want to add is about AI, right? So this is already complicated. And now you add AI to it. Let's say you use ChatGPT, for example, right, to train and further improve your work. Do you realize that the learning model will be elsewhere, especially those in the public, right? And I would imagine these are really difficult to protect moving forward, because I don't see any regulation, talk about those rights. And in the States, I think they start having certain issues like that. But in this part of the world, it's still far behind, right? So those are the things that you may need to watch out.
Great. And Monica, any comments on AI or trade secrets? Okay. All right. So with that, I can't believe we're already towards the end of our time, but I want to make sure that hopefully it's sparked your interest, and some of you have a question to ask. So let me open it up to the audience for any questions. No one? Question?
If you have no question, I have a question to the audience about AI. Is it okay, John? Okay. I believe that all of us that are familiar with the legal script, so that you will compare your script. Maybe there's some things that you are not familiar, maybe that you want to know, but something that new for you. So you go to AI, correct? So, about AI, John, how about your experience with AI related with intellectual property? Is it okay for the legal that to use AI? Because it's for me, when our client meeting yesterday morning, it's so funny when they present me for the AI. Monica, we have that. This one is AI information. This one, and I said that for the legal, please go to the real website for the government regulation. Don't open AI, because there is so much different information that we cannot get the real regulation from the government for. It means that, is it correct we can use that government regulation, or is it correct that we can use that for the treaty regulation or else? So many people right now, John, as a legal professional background, that I heard them, they also that open AI for the legal script. How do you think about it? Because that intellectual property, right? I'm so sorry, John. This is because for the legal act, in my experience, that I must make by myself as the author. So I know that we will win success or not. Okay, so I must stop. If I know that the evidence not support our legal act, the script, I will say that I suggest, hey, this is going to be failed because the supporting document not found by your team, right? But how can that legal that can say that, yeah, we can do it by AI? I said that it's so different. So that's, John, is it, in your opinion, with my explanation, is it okay for you that a legal professional that they use AI to to do
So-
something information or else?
So I think that, we probably can all agree that this is still trying to figure itself out, right, globally. And, I'm aware of some law firms that use a constrained data set to even help draft patent applications. But I think ultimately, while it's a helpful tool, I think it's important to interrogate that tool, just like you would interrogate an associate drafting a patent application for the first time. And I have found in everything I've ever done in AI, and I was sharing some examples with Monica yesterday, I've always found errors. And so you need to be vigilant and not take what you're seeing for granted. But then in the US side, we're still coming forward with our formal positions. But generally what we're seeing is contributions by the AI itself. If there's no innovation, whether it be creation on the copyright side by the artist, or if it's no innovation by the inventor, it was all done by the AI, we're not granting patents to AI, right? So, but if it was used as a tool to help do some analysis or things like that, then, so I think that the difficulty over the next few years is going to be is there going to be a bright line? And as we know in the field of law, there is never a bright line. It's always being tested one way or the other. So, I think that's where diligence comes in, common sense comes in, and doing the best you can for your clients. And so if you're using a machine to draft and relying on that data, I think ultimately there's also a challenge is how these data sets were trained in the first place, and were there any violations of IP that have taken place in the training of the data set. And that's things that are still working themselves out. So it's a very complicated area, and it's something that we at the USPTO have taken a deep dive in looking at. There's several publications on our website as well as Copyright Office website on where we are and some of the things we're considering. And for example, it's a little weedy, but we had some guidelines to come out to remind the attorney that is filing applications to, and not only to remind the inventor, but also to remind the applicant's representative that there is a duty to disclose information. You can't hide things from us. If we find out, you'll likely lose a right if it was granted. And there is also a duty of what we call reasonable inquiry, which means you should be asking the questions of your clients in the creation of the invention that you're helping them obtain rights for. And so those are some of the recent guidelines that have come out.
Okay, and Gilbert, how about your perspective?
I mean, I already mentioned just now, right? This is the uncharted territory, and no law. It's just like you used to cross the road with traffic light. Now you are in a country with no traffic light. That's all I can say.
All right, thank you. That spurred any questions? We can take one. Otherwise, I see a question. Yes. We have a microphone. Thank you.
All right, good afternoon. Yeah, good afternoon. All right, so I think it was well covered, and what I noticed is Monica asked all of us a question, but she answered the question herself. And while sitting here, I think she has, she's there, but taking all the questions and addressing us. But she also had the mindset of people sitting out here, what they think about people sitting out there, okay? So, she answered she asked the question, she answered it. My question is, since we're talking about blockchain, AI, right? So blockchain is more related to, more dominant in the financial world, right? And AI, as you know, it's a household thing nowadays, right? So every kid would have access to AI in the form of ChatGPT, every office's legal counsel, whether we should use it, not use it, And as the gentleman said that, there are a lot of errors, and I do see a lot of errors in ChatGPT. So AI is more into it picks up from machine learning, neural networks, LLM models and all that, right? And more used up in the services industry. So where do you think, my question is, where do you think that, who would take help from whom? So is it that blockchain would take help from AI because AI is rapidly expanding and we don't see blockchain except for a few industries and domains as a dominance. So where do you see both of them meeting together and solving world's problem? That's my question.
Gilbert, you want to try, or I can respond?
Okay.
So I'll just say from my perspective, I've been excited to see more and more what blockchain is capable of. And I actually think there's a solution there. I'm very optimistic when it comes to IP enforcement. But I think there is a way using blockchain technology to ensure, to help tackle the counterfeit products that are out there. And we've started to see that in some high-end products, but I think ultimately finding a solution could help address this huge challenge we have with counterfeits flooding the markets around the world.
So you are saying that since it involves a lot of proof of concept and proof of work, so blockchain is more reliable than machine learning concept, and which normally.
I'm not going to say one is more reliable than the other, but I think there's a solution there, an innovative solution that can help us tackle a global problem if we focus on it.
Yeah, I mean, I would say let's look at them as two different tools, right? So you can't compare the tools of two different functions, right? So blockchain to me is a tool of tracking. I think that is quite fair. AI is a tool to help your work to be improved, and you correctly pointed out the gist of it is in the model, and who owns the model. So that is a hot topic today that to me is a challenge. That's why I said we are into uncharted territory, right? There is no specific law that I know of that can really well protect that model, because don't forget, all IP is jurisdiction. So how about your model in two countries? That's it, right? So at this point of time, I really don't see how this thing is going to be regulated. But of course, at the field, I think most people will be very careful that they build their model in-house, well control all that. And if you rely on the public learning model, then I'll just say good luck, right?
Right. See, I have one connected question, if you don't mind.
I think because I do have another appointment, that's why I don't want to. So maybe
okay, I'll make it very quick.
Okay, please.
Okay. So the reason I asked that question because when we, as an auditing company, when we assess a lot of frameworks, right? There's an AI framework which has come, ISO 42001, right? So that also gets audited because many of the organization, small, mid-size, and large organization are using AI in the form of chatbots, or there are many other things. But we don't have a regulation for blockchain from the auditing standpoint, right? So how do we deal with it? Although people involvement is more in blockchain.
Yeah, I mean, to wait and see, my guess is there'll be regulations as with everything else, right? So some countries will come out with regulation that are probably much like in AI. We're seeing AI regulations that are overly restrictive, AI regulations that are not restrictive, and other countries seeking something in the middle. So the same thing is likely to happen, would be my thinking. So I'm just going to leave it there.
Thank you. Thank you.
All right. So thank you, everybody. Thank you.